History is important to our present and our future, and in no way is it more important than when it focuses on an individual and that individual's impact on his profession and his era. Many of his peers in legal education who have known Bruce Jacob for the past 20 years would describe Bruce Jacob as an educational administrator who served as Dean of the Colleges of Law at Mercer University and Stetson University. And among those who are interested in especially significant United States Supreme Court decisions would know him for his argument at age 27 before the United States Supreme Court in the case of Gideon versus Wainwright. But the story of Bruce Jacob is one of a civil rights attorney, a teacher, and a lifelong defender of equal justice for those who have all too often been the victims of the historical failures of our criminal justice system. For more than half a century, he has championed the human rights of those accused of crimes and the prisoners in America's prison system, thousands of whom, but for his efforts, might have been otherwise forgotten by a legal system that is responsible for justice for all people. And he has done this by pioneering the experiential education of law students through criminal justice initiatives, clinics, and practicums, which have taken a legion of law students beyond traditional classroom learning. His unique efforts have been transformative in legal education and in the legal profession's commitment to social justice. This documentary interview with Bruce and Ann Jacob is meant to tell the kind of story depicted in Professor Anne Emanuel's great book about Judge Elbert Parr Tuttle, the story of a career and a marriage born in youth, confidence, and love, and that would become a remarkable journey because each has admired and inspired the other. Let's begin with the idea that Judge Cardoza explained when he said that life is experience. Florida is one of the largest states in the country, but it's one of only 3 where the majority of its citizens are not native born. And you were born in Florida. And Bruce, while being born in Illinois, you spent your youth in Florida. And then as a couple, you've lived in 4 other states: Illinois, Massachusetts, Ohio, and Georgia. Looking back now, in 2016, how, if at all, has that influenced your perspective, and what did you like most about that experience as a couple?
I think there's a tremendous advantage in living in different places because you meet new friends, you learn things from every place you live. Being in Illinois when I was young, until I was about 16 years old, it's a very liberal state. We were taught that there's no difference whatever between races. In high school, I played basketball and ran track against African American students. We had some in our high school, and then I moved to Florida in my junior year, and it was a real shock. Schools were segregated. You never really saw African Americans. We had a restaurant, and at that time, blacks could not sit down at tables. And so they would come into a restaurant, they had to buy food to take out. And it was really distressing to us about that. If we had tried to let them sit at a table, the police would have been there. That's the way Florida was. So that was a.
And remind us of the year.
This would have been 1950. Let's see, 1952.
Just before
1953.
Brown Board of Education.
Yeah, it was before.
What you're talking about, Bruce, is a watershed in American history.
Mm-hmm.
And you just happen to be living the experience that preceded that watershed movement.
That's right.
So your observation makes Brown very visual for folks who hear you describe.
But a black student from Booker High School came, and we met each other, and we'd talk. He'd come, and we spent a lot of time together. And also, probably my best friend in that restaurant business was our cook, Rosalie, who was really my best friend, and she named her son after me. So I was caught between two worlds. And then after that, of course, we moved to the north, and we left the segregated South. In 1953, 54, I was at Principia College in Illinois when the Brown decision was handed down. I thought, oh, that's wonderful. I remember other students there thinking, oh, it's terrible that now black students will go to school with whites. And I thought, that's crazy. Why do they feel that way? So anyway, I lived through the early stages of the civil rights, earliest stages of the civil rights movement, and learned a great deal from that. Go ahead, Ann.
And you were native born. Is the life you saw, like Lillian Smith describes in her great book, Killers of the Dream, a different life, that southern life of Florida?
Yeah, I'm going to start with Florida with my youth, and then go to where we moved. I grew up in Lakeland, which at that time, and this was shortly after the Great Depression. Well, the Great Depression was just ending in 1938. So you had all the families were not spending a lot of money because they'd been through the Depression. They lost some fortunes. No one had a lot of money at that time. Florida was not a large state at that time. We just had a great influx in population after the Second World War. So at that time, when I was young, Florida was small. The towns were small. Things were simple. Life was simple. We lived in old houses. You didn't spend money on houses. You lived in smaller old houses. They all had alleys in the back, and you would go to school. I would ride my bicycle with a bunch of students for about 15 or 20 minutes to school, to elementary school. And then when we came home, we would go outside and play. And the last thing my mother would say before I went out the door was, watch out for snakes. And that was true. You had to watch out for snakes at that time. Life was simple. We played. There was no TV. There was no internet.
Radio.
There was radio, but there was no TV. There was no internet, and there was no mobile phones. So there were children in every house along the way. So there were millions of kids to play with, and we'd go outside and we would play. We would jump rope and play hopscotch and have guava fights. And on the alleys, guava trees would be growing at every.
So your experience was truly that rural Florida that preceded air conditioning.
Yes.
And tourism would not have been the news of the day.
No, we were.
Florida. It was the same simple country life that I lived on a Pennsylvania farm.
Yes.
Was there anything unique about Florida that you knew at the time? Or did Florida's persona really evolve throughout your lifetime?
Well, my parents were farmers. So my father and my mother's, both sets of grandparents owned orange groves. And my father and mother not only owned orange groves, but they owned a ranch. So we were close to the soil. We saw the simple life in the country as well as the most sophisticated life in town.
You lived in town, but
we lived in town. But every Saturday we would go out to the ranch and ride horses. So I got a very good, substantial. I don't want to say upbringing, but my parents really taught me values, and I think that's what I took from Florida. And I built on them when we went to other states and enjoyed living.
Because you retained that depth. I think many people who don't understand farm villages miss the historical fact that people lived in town, and yet they had farm country, their farm, nearby, adjacent.
Yeah.
And so they had that dual life, and town wasn't city. Right. That's what I think we miss.
Yeah.
The town doesn't mean urban. It just means that house that's in town, but right next to everyone's farm.
Yeah.
Where and how did you meet?
Oh, we met in a wedding. Very romantic. My cousin, who was my age, and we were very close. We were close as sisters, lived in Tallahassee. And she married Bruce's roommate from law school, who also was working in the Attorney General's office in Tallahassee. So they married, and they wanted us to meet. And for some reason, we were not. I was living in Lakeland. Bruce was in Tallahassee. We just weren't able to meet before the wedding. So the night of the rehearsal party, everyone was dressed up for the rehearsal. And I was coming up the stairs of the old First Presbyterian Church in Tallahassee, and Bruce was coming down the stairs. And I was with Jim and Mary Lynn, and we got introduced, and we have never been apart since that time. It was truly love at first sight.
Bruce, what was your first impression of Anne? I gather it was the anticipation of meeting her.
I was very pleasantly surprised. I thought this is one of the prettiest and nicest girls I'd ever met. It was, I was really lucky to be able to match up with her.
Oh,
I think the first night we were together, we talked about getting married.
we did, and it shocked our children. Our children can't believe it would do anything that stupid to talk about.
That fast, yeah.
The possibility of getting married.
As you got to know each other, did your visions of where life would take you develop immediately, or did they sort of evolve?
Well, I was already a lawyer. I was in the Attorney General's office in Tallahassee. So we knew that I'd have a legal career. I mean, she knew right from the start, and knew immediately that our life would be as lawyer and wife. Of course, after we'd been married a few years, she went to law school at night up in Massachusetts. So we're both lawyers, both Florida lawyers. So we looked. I knew I wouldn't stay in the Attorney General's office permanently. Wanted to get into a law firm, and we did actually when we got married, just a few days after we got married, we moved to Bartow, and I began practicing there. And she was near her parents, which was nice, in Lakeland. So we saw her parents and also her grandparents who lived in Bartow. So
in your early view was obviously that Bruce was in the beginning of what would be his career path as a lawyer.
Yeah.
How did that affect where you saw yourself at that time, and how did that perhaps influence your vision of your short-term and long-term future?
Well, I knew for the first 6 months to a year that Bruce was going to be preparing the brief for the Gideon versus Wainwright. And I had been a secretary, so I knew I was going to be typing his brief or anything that needed to be typed. Also, the Xerox machine, copiers had not been invented. So Bruce would find an article in a book and want to preserve it, he couldn't just copy it. He had to show it to me, and he had 4x6 cards, and I would write everything down, and then he would file it. So although I ended up studying to be an elementary school teacher, I put that on hold for a year. And then I did that later on, taught 6th grade.
Bruce, before we talk about Gideon versus Wainwright, after law school, you had an immediate experience that I've read about in your memoirs, watching a trial in which a black man was convicted of the crime of assault. Could you describe the circumstances of that case and how it affected you at the time, and why you believe it is still relevant to the way our justice system worked?
I was in the Army for 6 months. Everybody had to spend at least 6 months. So I went to Fort Jackson, South Carolina, near Columbia. And one day I had the day off. I went into town. I was, of course, already a lawyer. And for some reason, I went to the courthouse to watch trials, to see what their legal system was like. And I sat in on a trial in which a black man was accused of assault. A woman claimed that she was assaulted by him right on a sidewalk in Columbia. And I kept waiting for her to say, well, he lunged at me with a knife, or he hit me, or he did. None of that. There was none of that in the testimony. Instead, he was staring at her. And she considered that an assault. I thought, this is ridiculous. There's got to be more to it. No one could be charged with a crime of assault if they haven't done more than just look at somebody. But all the evidence showed that he stared at her, and therefore the court considered that an assault. I had to leave before the trial was over, but I watched the newspapers for the result. It turned out he was convicted. And that was the most atrocious trial, the most unbelievable outcome I've ever seen in a case. It was absolutely absurd. And yet this was 1960 in Columbia, South Carolina. That kind of thing happened. And I'll never forget it. It's affected my thinking about the criminal justice process ever since.
So you saw very early, as the great Albert Tuttle says, that the life of the law really depends upon its integrity.
Right.
And its integrity has to be self-imposed.
And there's a lot of injustice. There's a lot of corruption, a lot of injustice, unfairness in the criminal justice system.
Let me ask you about another early influence on you as a person and as a lawyer. In your memoirs, you reflect a lot when you describe your early career on the subject of mentors.
Yes.
You mentioned names who inspired you. They included Dean Harold Sebring, your law school dean, James Brand, the former Chief Justice of the Oregon Supreme Court, Richard Irvin, Louis Tribble, and Judge Reeves Bowen.
Mm-hmm.
Why were these men such important mentors? And why do you believe that having mentors is so important for a young lawyer?
Well, I'll begin by saying that I know of no lawyer who's had better teachers and better mentors than I have. I've been very, very fortunate. Some of the greatest lawyers and judges have helped me learn how to be a lawyer. Judge Sebring and Justice Brand, who were teachers here. One had been the Chief Justice of the Oregon Supreme Court. One had been the Chief Justice of the Florida Supreme Court, and they both had been judges at the Nuremberg war crimes trials. And then, of course, when I went to the Attorney General's office, Richard Irvin every morning would have coffee. As many as who could get away would have coffee for 20 minutes or a half hour or something like that. So I got to talk with Richard Irvin often and learn a lot about Florida history, about Florida's legal history, its political history. Judge Brand, not Judge Brand, Judge Reeves Bowen was my supervisor. He's probably the best mentor I've ever had. He would assign a case to me, appellate cases. And he said, read the transcript. I'd read the transcript. He said, then come back and let's talk about it. I'd go back and talk about it. He'd ask me question after question. And soon I realized that I hadn't read carefully enough. He'd say, go back and read it again. And so I'd read the transcript again, and I'd come back to his office and he'd ask more questions. He said, okay, now you understand the case. Now what's the issue here? What issues should be raised? And we talk about the issues, and I'd go do research and I'd come back. Anyway, it was like a course in jurisprudence. It's one of the terrific lawyer. And then I went to Harvard, and Paul Freund, who was mentioned as a possibility for the U.S. Supreme Court under the administration of John Kennedy. And he had been the law clerk for Oliver Wendell Holmes. Can you imagine? And he raved about what a wonderful person. And he would play on a record Oliver Wendell Holmes's voice to us.
How would you translate that experience today to a message that while mentoring at that level might not be available to all students, that mentoring in and of itself is critical to a young professional's personal and career development?
It's very critical. These people molded me. They helped me. They trained me. I listened to every word they said. I learned from them. I can't imagine what it would be like to go into the practice of law without having people like that showing you the way.
I think so many times in legal education, we see law school and the practice of law as separate worlds. You remember, as those who shaped you, both teachers and practitioners, and you've put them in the same category. Do you think that's a proper translation of your experience?
I think so. I think the two are identical. What they do for the young lawyer is the same. It's true, the lawyer who's your mentor can tell you more about where to file and how to file and what language to put into a pleading, that sort of thing, which is important. But the teachers teach you how to think through a problem, how to approach a problem, how to raise the right kinds of issues. I put them all together. They all do the same thing, or they certainly did for me.
Bruce, your notoriety to many people is identified with the decision of the United States Supreme Court in Gideon versus Wainwright, a case assigned to you by Judge Bowen when you were 26 years old and serving as an assistant attorney general for the state of Florida, and which you completed while a newly hired associate at the firm of Holland, Beavis & Smith in Bartow. First, and you talk about having helped Bruce with that case. Did either of you see the significance of his being assigned Gideon so early in a young lawyer's legal career?
Well, we realized the significance of the case. And we realized it was going to take an awful lot of work to get a brief. It was going to, I think one of the reasons that Judge Bowen gave the case to Bruce was because he knew Bruce loved jurisprudence and he loved history and he loved to delve in old books and bring things to light. He took it as his mission that this was a very important decision and it had to be made correctly. And it delved with a lot of issues like, was it going to be retroactive? What was the vehicle that we were going to use?
Which part of the Constitution?
Which part of the Constitution you were going to use?
Due process or equal protection?
Yeah. So there were other issues that were before the court that Bruce had to answer. As a matter of fact, when we got to the Supreme Court, I was aghast. One of the judges asked Bruce what the population of Dade County was. I thought, oh, Bruce is not going to know the answer to that. And sure enough, he did know the answer to it. But the questions were to help the court come through with a wonderful decision, and not just whether we have counsel for indigent defendants or not.
Now, Bruce, since you agree with Ann and always have, that the decision of the court was the right decision, how difficult was it to argue the case on behalf of the state of Florida?
But I saw my mission as being, I wanted to be a help to the court by giving them a thorough research, doing very thorough research. And in my appendix to the brief, I looked at every case in every state in the country on the subject of right to counsel. Took hundreds of at least 100 hours, maybe more, to do all that research. But I wanted the court to be informed. I felt my job was to do my best to teach the court or let them know what the issues were, and the history of the right to counsel and what was being done in every state in the union. And also there were some other issues besides just the main issue of whether counsel should be provided to indigents in felony cases. Like I say, which part of the Constitution? Equal Protection Clause, the Due Process Clause. The court couldn't decide that. The court just said 14th Amendment in their opinion, because it was so difficult to determine which of those should be used. And the question of retroactivity, should the case be retroactive? So there are many issues beside the main issue in the case.
Bruce, the Gideon case is obviously also famous because of your adversary, Abe Fortas. How would you describe your relationship, your mutual purpose as officers of the court, and your experience during the case?
During the hearing before the Supreme Court, of course, he went first, his argument was interrupted at noon for lunch. Staff persons in the court took us both one floor below the level of the courtroom in a small room like this for lunch. We sat at a very small table across from each other. He talked about Justice Black and how much he admired Justice Black. He talked about the case in which he represented Lyndon Johnson in Texas when Johnson was selected to the Senate. Then we went back to the courtroom. He finished arguing. I argued. After the arguments, he came up to both of us in the hall and said, I felt I'd done a terrible job. But he said, you have a wonderful way before the court, which meant a lot.
And you might agree or disagree. I think he understood the difficulty of your position. And that's why he told you that you had the ability to work along the same path that Anne described about the issues in the case, and that the outcome had to be a very deliberative outcome that really got it right. I think that's what he respected about you, and that you could do that at such a young age. And I'll leave my perspective there and won't.
I liked it very much.
And Bruce, Gideon changed your life in many ways. One of the articles written about you says, the man who won by losing.
Yeah.
Because since 1963, the year you decided to enter teaching, you have represented thousands of America's prison inmates. I know that this seed was planted in 1963 when you were doing graduate work at Northwestern Law School, and that the subject of your thesis there was the right to counsel, and that your major professor was helpful in your achieving your first teaching position at Emory. Your empirical work at Northwestern was, for those of us who read your memoir, the beginning of the idea for the Legal Assistance Project created at Emory. First, could you tell us the story of Judge Hooper actually swearing you into the Northern District Court and assigning you a case that became White versus Blackwell, decided in 1967, because that's a part of the seed that became this great program that you've created and sustained over these years?
Well, in the fall of 1965, I started teaching at Emory Law School, criminal law. And after a week or so, I received a call from Frank Hooper, a U.S. District Judge in downtown Atlanta. He asked if I'd come and see him. So I drove down there and met with him. And he said that he knew I taught criminal law, and he had a case involving 3 inmates who wanted the help of a jailhouse lawyer. And there was a jailhouse lawyer named White, Robert Joyner White, who was willing to help them, but there were rules of the prison that prevented a jailhouse lawyer from helping other inmates. And if that happened, the prison would take away all the legal papers, including irreplaceable documents, burn them, throw the inmates into solitary confinement. He said, would you be willing to, if I could appoint you, would you be willing to handle this? It's going to be a trial. It'll last several days. The jailhouse lawyer filed a federal lawsuit, and it was assigned to him. I said I would be willing to do that. However, I'm not a member of the Georgia Bar. I'm not a member of this court. He said, that's no problem. Raise your right hand. Yeah. Maybe a lawyer, a member of the bar of the Northern District of Georgia, which was all I needed really for representing inmates in the Atlanta Penitentiary. So anyway, that's how I got started. We had a 3-day trial. We won the case.
And that turned into your helping in the case that we all know about in legal history, the decision of the Supreme Court in 1969 in Johnson versus Avery.
That's right.
Could you tell us about that case and how Johnson grows out of the White case?
In Nashville, Tennessee, lawyers had there was a similar case, and the lawyers had lost at that level. And they wanted to appeal or take the case up to higher courts. And we, of course, had done all the research. We had reams of, files full of information, research and pleadings, motions, and so on. We had worked for months on this case, filing various motions and discovery and so on. We set everything up there to help them and answer any questions they had. They used this in the case of Johnson versus Avery and won that case of the Supreme Court involving the same issue as White versus Blackwell.
And then Judge Hooper asks you to review prisoner petitions.
Yeah.
How did that lead to your program in Emory?
Well, he called me again, and there were only two judges in Atlanta, Edenfield and Hooper, both terrific people, by the way. He called me again, and I went to his office. He said, Judge Edenfield and I get these petitions every day from inmates at the Atlanta Penitentiary, and usually you can't even understand them. Inmates don't know how to put their request into language that we understand. It sure would help if you and students at every law school could screen these things for us, could read them and decide which ones are good and not, and maybe file habeas type petitions in their behalf.
And every time you tell that story, the words that stick are, and he asked me if I and some students at Emory could do this, could review these petitions.
Right.
Because when you began the program, I think your biggest surprise was that you received 53 students who wanted to participate, volunteers who wanted to participate in that program.
Every day, we would go out to the institution. I'd take one or two of them with me. We'd drive out there and interview as many as we could. We when they signed up, they would be number 1, number 2, number 3. We eventually had about 900. And we would go through them by the numbers, as many as we could each day. Sometimes if an inmate had a due date on a pleading of some sort, of a habeas corpus petition or something along those lines, we would skip over some to get to that person who had an immediate problem. But anyway, we were filing petitions. We were going to court. I argued cases before the Fifth Circuit, now the 11th Circuit. We were very, very busy. I remember one Saturday, Ann and I were shopping, and I just got into a panic, shaking, wondering whether I had filed a certain petition on time. It was, we had so much going. It was just unbelievable.
Now, the other side of this situation is the federal prison system itself. How did that system respond to the program? We know that Judge Hooper was innovative in seeing this possibility as a way of translating prisoner petitions into a program and a format that could raise legitimate issues of inmate rights.
Yeah.
But it takes the federal prison system's cooperation to make this program successful. And you've told me that the Atlanta Federal Penitentiary, was indeed cooperative.
Oh, very cooperative. And the reason was that Judge Hooper and Judge Edenfield told them, give Jacob and his group anything they want. So we had no problem whatsoever with the prison officials.
Bruce, before we talk about the program in its larger context, if there's one special story about the beginning of your Emory program, it's the story of Harold Kaufman.
Yeah.
Could you tell that story?
Harold Kaufman was number 1 of the 900. He was the first one to apply for help. We had these applications in the prison library. He was the first one to apply. He wanted to file a certiorari petition in the United States Supreme Court. He had lost in the Eighth Circuit, St. Louis, and we had 90 days in which to file a certiorari petition in the Supreme Court. So we were under time pressure. I and one student prepared the certiorari petition for him and filed it, and certiorari was granted, which is very unusual. Certiorari is almost never granted, but was granted for us. And so the student and I worked on the brief. Well, first of all, the Supreme Court asked him who he wanted for his lawyer before the Supreme Court, and he said, I want Bruce Jacob. So the student and I prepared the brief, and we went there and I argued the case. We won the case. Abe Fortas was one of the lawyers on the court. I think Not sure he wrote the opinion, but anyway, by that time he was on the Supreme Court, and the case was sent back to St. Louis for retrial. At the retrial, he wanted me to come, but I was busy as a student at Harvard, and so we had a lawyer appointed to represent him at the retrial, and they pleaded. He got 12 years less. I learned later on, he did 12 years less. He served that time at a prison farm, which he loved. He was outdoor planning, and he loved the last couple of years that he spent at that prison farm. Years later, I read in the newspaper that there's a movie on TV that night involving Harold Kaufman, a prisoner, federal prisoner who was released and infiltrated the mafia for the FBI. And so we watched the movie. It's called A Deadly Business. We watched the movie, and sure enough, it was my Harold Kaufman. He entered the FBI, entered the mafia, and after he entered the mafia, he saw that they were doing terrible things. They were taking poisons and running up a highway and dropping off the poisons as they ran up and getting paid a lot of money for getting rid of poisonous materials. And so he decided to be an infiltrator for the FBI. He went to the FBI, and for 2 years he wore a sound microphone. And so all his conversations with mafia members in New Jersey were broadcast to an FBI van, which was located nearby. And at any time, if they had realized what he was doing, of course, he would have been killed. And so the day after we watched this movie, I get a phone call from the FBI. They say, "We have Harold Kaufman on the phone. Would you like to talk with him?" I said, "Of course." And so he comes on the phone. He said, "Well, how did you like it?" I said, "You mean the movie?" He said, "Yes." I said, "God," I said, "I'm amazed at how much courage you had. I've never known anybody with that kind of courage."
And then he told you why he had called you.
He said, I said, "Oh," and then it reminded him that when I first met him, he said that his goal in life had always been to be among the 10 most wanted men in America, because on the post offices back in those days, they posted pictures of the 10 most wanted criminals. That was his goal. Oh. And I said, "Harold, why did you change that goal?" He said, "It was because of you and the boys at Emory. I never had anybody do anything nice for me before."
You and your students.
Oh.
That to me is just one of the great stories of your legal career, if not the greatest. Now let's get back to the Federal Defender Grant Program. The Federal Defender Grant Program grew out of your legal assistance to inmates program in Emory and carried on after you left for Harvard to pursue work there under a Ford Foundation grant. This has always seemed to me to be, this program, the essence of thinking outside the box and yet thinking with common sense. Could you tell us about that program, and particularly the involvement of two men named Robert White and Benny Rayburn?
Yeah. We had so much work that there was just no way of handling it ourselves, me and the student who had hired as the assistant director. So John Cleary, who was the deputy director of the National Defender Project, which was funded in turn by the Ford Foundation, visited us. We were one of his grantees, so he visited us, and I said, "You got to meet this jailhouse lawyer, Benny Rayburn, who I had gotten to know, fabulous person." We went out to the prison, and we met White, and we met Benny Rayburn and talked with them.
For those who may not know, before you talk about these two men, describe what we mean by the term jailhouse lawyer.
They were prisoners who had done a lot of studied the law, and were willing to help other inmates. So they were the two best at the Atlanta Penitentiary, and Rayburn in particular was a wonderful human being. He was a great person. He had headed up a Jesse James type gang in Kentucky following the Second World War, robbing payrolls at factories on payroll day. And the girlfriend of one of the members of the gang had said something to someone. Anyway, they found out he had been sent to Alcatraz. When he first sent to the Kentucky State Prison, he kept escaping. So then they sent him to Alcatraz because he had a concurrent federal sentence. He couldn't escape from there. So he took U.S. Code annotated page 1 to page 100,000, read it, every bit of it, and became a fabulous criminal lawyer. So anyway, we were able to get them both out on parole, and they were supervisors at the law school. So you'd see Benny Rayburn sitting with a student in an Emory library working on a case together, and they got the 900 cases. They were able to get by that time I had left to go to Harvard to do graduate work, but they were able to finish those 900 cases. Eventually, Rayburn went to San Diego and became a paralegal in the San Diego Federal Defenders, and he was so respected by the judges that they allowed him to argue cases before the Ninth Circuit.
Now, during your SJD program, which is a multi-year program,
right,
much of it being conducted by independent research, which led to the completion of your thesis a few years later on the criminal sentencing system, you moved to Ohio State University.
Yes.
Could you talk about your program there and what seems to be a rather considerable expansion of clinical and practicum programs for students, while at the same time serving people previously unserved by the criminal justice system?
So the first thing I did was establish a legal services, civil legal services program. We call them practicums. And we hired a staff attorney, and we had one full-time faculty member teaching that course together. Then I established a clinical defense practicum. I was the teacher, and we had a staff attorney helping me. We'd take 20 students at a time. We'd have class sessions, and we also would be handling cases at the same time. I established a juvenile delinquency clinical program or practicum. Hired a full-time professor under a grant for that to teach that program, and we hired a staff attorney for that. And while I was there, we established 13 clinical programs, each one headed up by a full-time faculty member with a staff attorney assisting. And there was a classroom component plus the handling of cases. For example, a housing discrimination clinical practicum. I got a real property teacher, a very famous lady, became dean of Buffalo Law School, to be the faculty member. And we had a very prominent lawyer downtown who handled a lot of housing discrimination cases. They teamed up together, and they told me that they had learned a great deal from each other in those classroom sessions.
And this program had a journey that exists today. You brought that program, or a version of it, to Stetson University College of Law in 1981 when you became dean here.
Yeah.
And we had a number of clinics with that concept of a teaching component and a practicum component. Yeah. And a version of that program ended up migrating to the Southern Poverty Law Center in Montgomery and other places.
Well, my best clinical student, Dennis Balski, was hired by us as one of our supervising attorneys, and he left after a couple of years and worked at the Southern Poverty Law Center, trying death penalty cases. So we were training people who went out. I got a letter from a former student in West Virginia saying he spent his whole career, he's probably in his 70s by now, his whole career as a public defender. And he said it was all because of our clinical program that he got started doing that.
So when we talk today about the new idea of experiential education, it goes back.
Oh yeah, the clinical education movement really started in the 1960s. So it's nothing new.
Now, Bruce, while you're at Ohio State, the idea is planted by someone else that you should respond to Mercer University College of Law's need for a new dean. And without a deliberate plan to transition your career to administrative leadership, you do accept the position of dean at Mercer.
Right.
How did that new experience shape you, and what did you enjoy the most about that transition?
When I moved to Mercer as dean, I did miss the collegiality, the fact that I had close friends on the faculty. Now I was setting their salaries. So I felt a little bit of distance. Probably shouldn't have felt that way, but I felt that it was the collegiality that had existed at Ohio State wasn't quite the same. However, there were compensations for that. I really enjoyed being dean because I had a chance to mold a law school, to build a law school that really needed a lot of work.
And Bruce, it must have been a uniquely enjoyable experience to come from Mercer to your alma mater, to become its dean.
It was a wonderful experience. My years as a student here at Stetson had been some of the best years of my life. I made wonderful friends who now are alumni. So coming back home was great as far as I was concerned. I saw a number of improvements, or I realized there were a number of improvements that could be made here at Stetson. One was that the faculty members were teaching at terrifically heavy loads. By lightening the loads, this made it more possible for faculty to do research and writing, which I thought that we really needed to do.
I can speak from experience that it was indeed a sea change illustration of your career, that you created faculty members as teachers and scholars, each endeavor reinforcing the other. Now, Ann, I want to take you back to two stages in this long story that we've been telling. First, I want to go back to Bruce going to Harvard. You moved to Cambridge and embark on your legal career.
Our third child was actually born in Cambridge. So about 6 months after the third child was born, I started law school. I started night law school in the downtown area.
Your life in Atlanta had been very Emory oriented, very Atlanta community involvement oriented.
Yes.
So the move to Cambridge really alters that.
Our life went something like this. Bruce would go to Harvard, and I would have the children. Now, the children were 6 months, 2 years, and 3 years. So that was before they started any kind of preschool program. So we went to Harvard museums and all sorts of things during the daytime, having fun with the children. Then they would take a nap. Well, after they got up from the nap, and I would study during the time that they took naps. And then I would feed them and get them in their pajamas. And Bruce would walk in the door from Harvard, and I would walk out the door to go to night law school for a couple of hours in the downtown area of Boston. We organized our lives, and we were young, and we could do it. And so everything just worked.
And now, Ann, part two of this journey. When Bruce leaves Mercer and comes to Stetson as its dean in 1981, you return to the place where you were born with a law degree. But your experience does not become the entry into the practice of law nor law teaching.
Well, I was a member of the Florida Bar, and I assumed that in moving back to St. Petersburg, I enjoyed working with environmental law. So I thought I would either work environmental law or something with children or women. But I was going to wait till I got to St. Petersburg to get a job. I talked with EPA at one time, and they were excited, said when I finished law school to talk with them. But I put this on hold. But the first time we saw my parents, my father, who was in his 80s, said, "Okay, you're back in Florida. You're going to run the Groves." Oh, my dear. I didn't even know where the Groves were. I was just stunned. I knew more about the ranching business than I did about the orange grove business. So we had to think about what Ann was going to do. And you had to, I wanted to please my father. The Groves had been in our family for 100 years. I really wanted to do that. I was a sixth generation Floridian who those generations had come into the Panhandle and planted cotton. So we were farmers from the beginning. And I knew that. I also knew what it would take to be the wife of a dean, because Bruce had been the dean at Mercer, and I knew that at that time, which was 40 or 45 years ago, the dean of a law school was like a minister's wife. We really had to do similar duties.
Bruce, back to your career at Stetson. When you step down as dean, you continue your work individually on behalf of prisoners and the rights of inmates. It's a never-changing need.
Mm-hmm.
Why have you continued to play that role to this very day?
Yeah, inmates obviously have a very rough time. Prisons are dangerous. Conditions are not very, very healthy. And many of those who write to me are serving life sentences or the equivalent of life sentences with no possibility of early release. And so I think a lot of what I do is to improve their morale, hold up some hope for them. And some are just like corresponding with me. I do that just because I think it helps their morale. It's good for I think lawyers should do that. Every lawyer should do some of this kind of work.
How does it touch you that you can play the role of perhaps not hope of freedom, but the role of being an advocate for some level of fairness and decency in the environment in which many of these men spend their lives?
That's a very good way to phrase it. They deserve decent life. They deserve to have at least a shot at getting out of prison sometime before they die. Their situation seems hopeless, and they need someone to at least work with them, help them, give them some hope, make them feel like human beings again.
This is a broad and perhaps political question. We still seem in 2016 to strike a chord in people when we demand law and order.
Mm-hmm.
And the idea of human rights seems somehow more elusive. How do you balance the two? And would you say that you have hope that we can emphasize human rights as much or more someday as we do law and order?
I wish we could reverse the trend that's been taking place throughout the years that I've been practicing law. I began handling criminal cases in 1961. Back in those days, the theory of punishment that was prevalent was the rehabilitation theory. We sent people to prison to punish them for what they did, but we didn't over-punish them. And we gave them an opportunity to show that they could again live in society as decent people. They could get their high school equivalency by taking courses. If they had a good disciplinary record, they would be released on parole. They'd go out and they could prove themselves. They might come back in, but in many cases they did prove themselves and become responsible citizens. That all changed. We abolished parole boards. We don't have parole boards anymore. And we have mandatory minimum sentencing now. Person is sent to prison for 40 years with no opportunity whatsoever to ever get out of prison. So the prisoners lose all hope. Prisons are more dangerous because of that. Prisons are very crowded. Back when I was practicing in Florida, we had about 6,000 or 7,000 inmates in our prison system. Today we have over 100,000. Inmates go to prison for much longer terms. That's one of the reasons we have so many inmates.
And the loss of the independent judiciary.
That's right.
With things like mandatory minimum sentences, you've told me deprives the judge of some of the very most important aspects of the role of the judiciary.
Judges often have no discretion because the legislature has passed laws that require the judge to impose a certain sentence, a very heavy sentence, regardless of the judge's own feelings. There might be hardship circumstances in the case, but the judge has no discretion whatsoever. The judge has to impose the sentence that the legislature has said he has to impose.
Advances are being made. Diversion programs, while still small, such that they can accept only a very few cases, have been extremely successful as experiments.
Yes.
And with juveniles, at least, we're hopefully beginning to move in the direction of an alternative to incarceration, to an alternative dealing with youth who many scholars say should not be treated as adults. Do you see any of that light at the end of the tunnel in the adult criminal justice system?
Not much at the present time. We've been moving toward a law and order model for our whole criminal justice system, and I don't see any retreat. Not much in the way of a retreat from this model of law and order, long prison sentences, no parole boards, no way of obtaining an early release, a heartless system. And because the system is so unfair, I think the criminal justice system has lost a lot of respect. There's a tremendous disrespect for the whole process because people see how unfair it is. You see people who may have possessed marijuana going to prison for 10 years. They see people because they're minority members of a minority race being sentenced much more harshly than a white affluent defendant. They see the unfairness in the criminal justice system has a terrible reputation, and people don't want to show any respect to it because it doesn't deserve a whole lot of respect today.
And as a lawyer yourself, how do you see today the system that he's worked within for 57 years? Do we have hope that the work that Bruce has done for all these years may someday not be so necessary?
He hasn't changed over the years. He loves the law. He believes in the law, and he's just battling it out, trying to make it work. He knows it should work. He knows it can work, and he knows sometimes he can make it work, and he hopes.
Bruce, not long ago, you received the Champion of Indigent Defense Award presented by the National Association of Criminal Defense Lawyers on the nomination of Professor Ellen Podgore, that you should receive that award. I want to tell you to end this interview on behalf of all those who see it, that you and Ann are a remarkable couple, engaged in a remarkable journey to defend those who most need equal justice. And we thank you for the stories that inspire us to live the kind of life that the two of you have lived. Thank you for being with us today.
Well, thank you very much. Thank you.